And so for tonight's presentation, that part of that learning component for our families is understanding conservatorship. And tonight we have the honor of having Ms. Alma Viteri, who is the Administrative Services Manager for the Public Guardian and Long-Term Care. Ms. Alma Viteri is has been working for County of Riverside for 31 years, serving in the last 13 years for behavioral health as the manager for these programs. She's responsible for the administrative support team, contract management, as well as ensuring the continuum of care amongst multiple facilities and departments. Ms. Viteri goes above and beyond the requirements of her position to ensure the county's most vulnerable clients are receiving the quality of care they deserve. And her being tonight is just proof to that matter by being here for our families. Also, our presenter tonight is our very own Ms. Deborah Johnson, who is the Assistant Behavioral Health Director of Programs. Ms. Deborah Johnson has been working for Riverside County for the past 43 years. Ms. Johnson works diligently for those in the community, often those without a voice. To have access to mental health services, she tirelessly goes above and beyond what is required of her position to ensure that behavioral health programs are operating properly. Ms. Johnson also works with partner agencies, community organizations, commission members, including consumers and family members, to ensure that all who are suffering from mental illness in Riverside County have access to appropriate services and have an improved quality of life. Evidence of that is her working long hours today, as she usually does, and being here with us for our families. We thank you both for being here tonight. I'm going to stop right there and allow you to utilize your time. And families, please take advantage of this opportunity. We are greatly honored to have Ms. Johnson here. And if you have any questions, utilize the chat and the raise your hand option. Okay, without further ado, here is Ms. Viteri and Ms. Johnson. The floor is yours.
Thank you so much, Pedro. Good afternoon. Well, I should say good evening. It's not afternoon anymore. I'm Deborah Johnson, and I'm going to go through this PowerPoint pretty quickly because I know there's probably a lot of questions. And as Pedro mentioned, please feel free to ask questions along the way. So we often throw around the letters LPS, and I'm often asked, what does LPS stand for? So there were 3 legislators in the state of California who got together to write some legislation around mental health, mental illness, and people being hospitalized for involuntary reasons. And so they decided that it was time to define some of the language in the literature that talks about involuntary care, conservatorship, and those matters. So the LPS Act stands for Lanterman Petrus Short. It's part of the California Welfare and Institutions Code. It's covered in Division 5, starting with Section 5000. And if you Google that section, or if you have the code, that's where it talks about 5150s, 5250s, temporary conservatorship, and other matters. The act was actually signed in 1967, and it went into effect in 1972. Next slide, Alma. So we're going to do a little summary of the LPS process, just to give you an idea of what happens. Next slide. So a person, as a result of a mental disorder, appears to be dangerous to self or others, or gravely disabled. Now, I want to add that when we get to the LPS conservatorship conversation, it's only as a result of a mental disorder that the person is gravely disabled. But individuals can be hospitalized if they're danger to self, danger to others. So I just want to point that out, because sometimes family members and community people think that we can apply for an LPS conservatorship because the person is dangerous to themselves or others, but it's only for grave disability. And grave disability is defined as a person, as a result of a mental disorder, is unable to provide for food, clothing, or shelter for themselves. Next slide. So when a person is 5150, the 5150 is just an application for an evaluation. The person can be held up to 72 hours. You can see, as I mentioned before, the criteria is 3: danger to self, danger to others, or gravely disabled, and it has to be due to a mental disorder. So within those 72 hours, and I'll use the psychiatric emergency services, which we often call ETS. An individual goes into ETS, the doctor has up to 72 hours to evaluate, to determine whether the person, one, is acute and need hospitalization, or two, that there's some alternative and the person does not need to be in the hospital. In a non-designated hospital, and here in the city of Riverside, hospitals as Riverside Community, Parkview, out in the desert, it might be Eisenhower, JFK, they're not designated 5150. So if law enforcement takes a mentally ill individual to one of the non-designated hospitals, they have 24 hours that they can keep them in the emergency room. At the end of those 24 hours, they need to be, well, I shouldn't say at the end, sometime during that 24 hours, up to the 24 hours, they have to be transferred to a designated 5150 hospital. Next slide. So only a psychiatrist can admit a patient on a hold. As you know, law enforcement, other individuals designated by the Department of Mental Health can write a 5150, but only the psychiatrist can admit into ETS. He has to be designated, and the psychiatrist is the only person that can break a hold. Patient rights is very active in the process. They're advised of every hold written in the county of Riverside. Patients have a right to file a writ of habeas corpus. That usually takes place during the 14-day search, because it's very difficult to process and get it in court on a 72-hour hold, although they do have a right to that. And so if a patient expresses a desire to file a writ, we have to do everything we can to process that paperwork and get it to court. Next slide. So 5250, that's the 14-day search. So the psychiatrist has evaluated the person, feels that based upon their behavior, based upon history, that the person should remain in the psych emergency services 72 hours. They're constantly evaluating, and then he has to make a decision whether to discharge or whether to then file a 5250, which is a 14-day search. Once that happens, the individual can be held up to 14 days. The patient writes, the patient is advised, there's a probable cause hearing, or the person can ask for a writ of habeas corpus. And I like to remind family members especially that once they're in the hospital, there are many statutes that allow the person an opportunity to be released. And, you know, it includes, you know, the probable cause hearing, where the hearing officer is going to listen to the evidence. Typically, a psychiatrist will testify. The patient rights advocate represents the patient. And if they lose that, they can then request a writ of habeas corpus in the superior court. So all along the way, they have rights. And so just because they're placed on a 72-hour hold or placed on a 14-day search does not mean that they're going to remain in a hospital. Next slide. So the probable cause hearing, or what they used to call Doe Galliano, and this is part of the statute. And in 1975, John Doe filed a writ of habeas corpus at Camarillo State Hospital and won. Therefore, the certification review hearings became effective. It's the rights of the patient. The patient can be represented by the patient rights advocate, family members, and others per the patient's wishes. And one of the things that is very difficult for families is there are times when the consumer will refuse to allow the hospital staff and or the doctor to provide information to family members. However, included in the statute was AB 1424, which gave the family members the ability to be able to write history information that the family member thinks is very relevant to the doctor in terms of his evaluation. And so when your family is taken to ETS, you have the ability to be able to provide that document and to leave that, and the staff have a duty and responsibility to review that and to use that, for information and for history. Next slide. So here, I just sort of outlined for you, 5260, which is danger to self. That's a person as a result of a mental disorder is danger to themselves. We can hold them 72-14 and then a second 14-day certification. They still have a right to a writ of habeas corpus. And so in the Welfare and Institutions Code under 5300, a person as a result of being danger to them others, we can file a petition to court for 180-day post-certification. They have a right to a court or a jury trial for release. If we prevail, then the consumer is held an additional 180 days for treatment. So the public guardian. The public guardian's office has probate, conservatorship investigations, LPS, conservatorship investigations, then probate conservatorship, Murphy conservatorship, and LPS conservatorship. So under the probate, typically the referrals can come from family members. The majority of our referrals come from the Superior Court. We often get orders to show cause. That basically means that the court is notifying us that there's a case in court and the judge wants the public guardian to show cause for why we should not be appointed, the probate conservatorship. And sometimes we do, if we've completed the investigations and there's a family member or there's some alternative, we will often write a report and put in all of those recommendations and typically say that it's not appropriate for the public guardian's office to be the conservator. In the statute under the probate code, we're the last. There's a list of priorities, and the priorities start with a mother, a father, sister, brother, and we're at the end. So typically we will do the investigation, and if there are family members that want to be the probate conservator, we try to work with them and try to help them understand what their duties and responsibilities are going to be. So we have a staff of that do the probate investigations. We have up to 30 days to complete the report and file it with the court. Same with the LPS. We have clinical staff, clinical therapists who do the LPS investigations, and primarily because this is the mental health conservatorship. This is where, as I mentioned before, a person as a result of a mental disorder is unable to provide for food, clothing, and shelter. The probate conservatorship is typically for people who get under undue influence. They're typically elderly people, mostly who families, have maybe migrated, somewhere not in the state, and sometimes they're here. But they're not able to provide for themselves any longer, and therefore we will get a referral for a probate conservatorship. We also receive a lot of probate referrals from the Department of Public Social Services, their Adult Protective Services unit. The Murphy conservatorship is a complicated conservatorship. These conservatorships happen when an individual who's committed a crime, spent some time in prison, and or county jail, and is the public defender or the attorney representing recommends to the court that the person, as a result of a mental disorder, is not able to take care of themselves. The charges are stayed, and stayed, what I mean is that they do not dismiss the charges, but they stay them, allow us to place them on a Murphy conservatorship to receive mental health treatment. Typically, depending upon the charges and depending upon how long they stay on conservatorship, eventually the public defender will go back to court and request the court to dismiss the charges, provided they're not serious charges. They're not going to dismiss a murder charge, assault charge, but if they have some minor charges, they will eventually, once we're on a Murphy conservatorship, ask the court to release those charges. The LPS conservatorship, as I said before, is the mental health conservatorship. Those referrals come from a designated 5150 hospital. Family members cannot apply to be an LPS conservator on their own. All the referrals come through the public guardian's office, and we are going to do an investigation and decide whether the public guardian's office should be appointed or whether there's a third party, meaning a family member who is desirous of becoming the LPS conservator. Next slide. And I know that I'm talking a lot and it can be complicated. So if you have questions, please put the question in the chart and ask me as we go along. Otherwise, we'll save some time at the end. Under the LPS conservatorship, if we do the investigation, determine that the person is gravely disabled, we will petition through our county council to the court to become the temporary conservator, which lasts 30 days. So under the LPS conservatorship, it is the public guardian's office who will always serve as the temporary conservator. Under the probate, a family member can be appointed as the temporary conservator. And we talked a little bit about the criteria, the grave disability, and it happens, we have to file before the expiration of the 14-day cert. So under the LPS, they're going to be on a 72-hour hold, a 14-day cert, and then from there into a 30-day temporary conservatorship. Only a psychiatrist can initiate the LPS conservatorship, and that application is forwarded to the public guardian's office. We review it. If we concur, we then file it, as I said, with county council, who then files it with the court. We have to notice the conservatee, I call them the proposed conservatee. We're required to notice that person, to give them a 5-day notice that we're going to file for a temporary conservatorship. Once it's filed, the proposed conservatee can request a writ. So you heard me talk about a writ at the 14-day cert. They then can file another writ once the temporary conservatorship goes through the court. Next slide. So grave disability, and I want to keep talking about this because it's important for you to understand that it's as a result of a mental disorder the person is gravely disabled. The petition is filed by county council, as I said, a 30-day. The conservatorship hearing is within the 30 days. The conservatee has a right to a writ, may be continued with cause up to 6 months. It is rare that we request the court to continue a temporary conservatorship for 6 months. And a good example of that is, a couple of years ago, we had a proposed conservatee who got on a bus from Louisiana, ended up in the county of Riverside. It took us some time to determine, while we were doing an investigation, that the person wasn't from California and had family members in Louisiana. And so we requested a continuance to make arrangements, one, to get the conservatee stable enough for family members to travel to Riverside to then return their loved one back to Louisiana. So those are the kind of examples where we might go into court and request the judge to continue the temporary conservatorship. Once the temporary conservatorship is granted, the proposed conservatee has a right to a court trial and or a jury trial if they are opposed to the granting of the conservatorship. Next slide. So if we're successful, the person is put on a permanent conservatorship, and permanent, almost, that word almost sounds like it's going to be for life. But in actuality, it only lasts for a year. And prior to the expiration of that year, we have to petition the court to continue the conservatorship for another year. Under the probate, the guardian may be appointed either us or could be a private person's. Powers under the LPS, the only powers we get is for placement and hospitalization, unless specifically granted by the court. Under the LPS conservatorship, the conservatee retains the majority of their rights, unless, like if we go in and petition the court and request a judge to grant us, the right. For example, a conservatee who develops a medical problem, and we're notified, and the doctor wants to perform some sort of surgery, we don't have the power to grant that. We have to petition the court and have the court then give us authorization to give the hospital and the doctor authorization to do the surgery. If the conservatee opposes, we have to go to court, and typically the judge is looking to see if the conservatee's decisions surrounding whatever procedure needs to be done seems like it is rational. I was looking for the word, it's rational. So that if they have a rational reason for why they're opposed to whatever the doctor's recommending, typically the court will grant or not grant that petition, but it has to be rational. We all have a right, as we know, to agree or not agree to medical treatment. And just as we have rights, the conservatee has a right, unless we can show that the person, as a result of his mental disorder, does not understand and doesn't have the ability to be able to make that decision. So as I said, the conservatorship is renewed for 1 year. The court is going to appoint either the public guardian or a suitable party. The court can grant conservatorship for the person only, person and estate. In the public guardian's office, we typically will request and recommend person and estate. We don't typically split the person and estate, although if the person agrees to a representative payee program, we might have the person and the representative payee in our office might then take care of the finances, especially if all we're talking about is Social Security or SSI, that they have no real estate. Then that's more appropriate to be under the rep payee program. So under the LPS conservatorship, the deputy public guardian has to arrange for the conservatee's care and protection. We make decisions about the level of care. The conservatee has to be placed in the least restrictive placement. Again, we have to make arrangements for their health care, their meals, clothing, personal care, and transportation if necessary. The estate, we pay the conservatee's bills and expenses on time. The court requires that we do an accounting every year where we have to account for the funds coming in to the conservatee and funds going out, and how much we're spending for the conservatee's bills and expenses. We have to file a final accounting of the estate when the conservatorship ends. So if the conservatee gets off the conservatorship, we then have to file the final accounting, and whatever monies is left is handed over to the conservatee or to the third party if there's someone else who's willing to help provide care for the conservatee. So probate, as we talked a little bit about it, typically these cases are physical abuse or neglect, self-neglect, financial abuse, inability to manage their affairs, or undue influence. And as I mentioned earlier, under the probate, a family member can petition the court. Under LPS, only the public guardian's office can petition the court. The conservatorship is meant to ensure the conservatee's basic needs are met. We have conservatees who come to our attention who are developmentally disabled. They may have dementia or other medical problems. And, you know, they typically don't have the ability to make their own healthcare decisions. And so the court will appoint us to make those decisions for them. The letters and orders from the probate court will give us our powers. And we, in this case, we also have to present to the court what the powers should be and what we should be granted, whether we should be granted the authority to make medical decisions or not. Under the probate code, typically the judge will give us the power to make those decisions for the conservatee. So LPS versus probate. So as I mentioned before, you know, it's grave disability as a result of a mental disorder. We can authorize a psychiatric hospitalization. We can place the person in a locked facility against their will. We are not able to authorize medical procedures or psych medications unless the power is granted by the court. And I think somewhere we probably will talk a little bit about RUHS hearings, but just real quickly, when a conservative refuses medications, it is the burden of proving that the person, as a result of the mental disorder, is making irrational decisions, is the psychiatrist. And so the psychiatrist files a petition with the court. He has to testify what the medications are, what the purpose, why, and, you know, his opinion that it will likely stabilize the patient, the pros and cons, and then the conservatee then will have the opportunity to state his or her reasons why they do not want to take medications, and ultimately the judge will make the decision. Under the probate, it's person and estate or a person and estate. We can, in most cases, authorize medical treatment. We cannot place the probate conservatee in a locked psychiatric hospital. If they go, and sometimes they do, they're usually under a 72-hour hold. In other words, the fact that we have letters and orders saying that we're the probate conservator does not give us the authority to place them in a psychiatric hospital. Yes, so RUHS petitions. So in order to get the court order for antipsychotic medications against the patient's will, it's only for those patients that are involuntarily held. It's irrational refusal. So, for example, at the county's inpatient, 2 days of refusal, the doctor can file a RUHS with county counsel, and we get a hearing. And again, as I stated before, the psychiatrist has to testify, and then the conservatee testifies, and then the judge makes a decision whether the person has to take medication against their will. So AWOL conservatees, like anything else, we have conservatees who are very sophisticated, who walk away from locked facilities, who walk away from state hospitals. And so it is our responsibility to try to locate the conservatee. We typically file missing persons with our law enforcement. We give a description of the conservatee, including, you know, whatever clothing they were wearing last seen. And then we try to have, you know, a conversation with the facility to discuss whether the facility is willing to readmit the conservatee upon his return. Typically, they end up at ETS, into ITF, and then we start placement all over again. We collaborate with ETS, ITF, and I had mentioned before that they are required to accept collateral information from family and significant others when a person goes to the ETS and if they're in the inpatient. AB 1424 mandates that the treatment facilities accept information, the historical course of an individual's mental health history. Next slide. Is that the end of the slides, Alma? I think that might be, is that the
Yes,
end?
it is.
Okay, so
Yes.
I know that there are lots of questions, so let's get to the questions.
So, Ms. Johnson, the first question was, can the, a few people asked, can we have access to the slides? Are we?
Yes,
Okay.
actually, Pedro, I will send you the complete PowerPoint because to save time, we took some slides out. So I'll make sure you get the complete slide, the complete
Very good.
presentation. Yes.
So on the chat, there is my email. You're welcome to write down my email from the chat and email me tomorrow. And once I have those slides from Ms. Johnson, I will forward those over to you guys. If you guys are able to see that, or if not, I can type it in again. Any additional questions? And this is the opportunity that we have. I want to tap a little bit, and this is a recurring question that I get from the families. When you talk about AB 1424 and the historical course of a mental health person's history, what's the most pertinent information? What should we add on there? And what does the public guardian need to know?
Well, it's actually for the hospital.
Right.
So it's when the individual goes into ETS and is going to be admitted to ITF. I often hear family members say, I talked to the doctor and I asked the doctor to place my loved one on a conservatorship. It's not as simple as that because, first of all, it is due to the behavior almost right now. Although, because of 1424, the court will take note of historical information. So what I tell family members, when I manage ETS, ITF for 20 years, what I would say to family members is, look, write notes. If he's not taking medication, if he's refusing, if he's home and he's not able to take care of himself, if you're having to do A, B, C, D, write that down, because the more that the psychiatrist knows about the conservatee past tense to bring it up to present tense helps when they're trying to assess whether this person is in fact gravely disabled because of a mental disorder. And often family members will, they will come to me with pages of notes, in terms of what medications they've been on, what hospitals they've been in, what treatments they've had, throughout their, time, when they were diagnosed, their diagnosis. Those are the kinds of things that's going to help that psychiatrist and the treatment team to kind of, decide whether this person, as a result of this mental disorder, should be referred for conservatorship. And then once the hospital does that, then we do our own investigation to determine whether the person, because we have to be, the public guardian's office, it's the conservatorship investigation unit. And we often refer to them as the CIO unit. They have to make a recommendation to the court that this person should be placed on permanent LPS conservatorship. And as I said, we have to have evidence to present to the court as to why we're making that recommendation.
Okay. Another question that we have, can a lawyer petition for LPS conservatorship?
No, only the public guardian's office, and the person has to be in a 5150 designated hospital or be in jail. I failed to leave that out because the court can refer, the superior court can refer a person to us. Other than that, it has to come through a 5150 designated hospital to the public guardian's office. Now, a family member can hire an attorney and come in and say, I want to be appointed the permanent conservatorship. And then in the course of our investigation, we'll determine whether the family member understands what their legal responsibilities are going to be. And then so we will recommend on the public guardian's petition, we recommend to the court that Deborah Johnson be appointed as the private conservator for, Jane Doe.
Okay, good. We have someone that wants to ask a question. Ms. T. Corral, can you open up your mic, please? Unmute yourself and go ahead and ask your question. There you are.
Once the family member provides that information, where is that information kept? Because I've had instances where I have a client who's on conservatorship and I'm having to explain every single time she gets hospitalized what's going on, and it seems like they don't have a history. There's no history being kept, and same with her family members are running into the same issues.
Well, it's kept in the medical record at the hospital because, it's confidential information. So, they review it and they may extract some information from it, but the conservatorship investigation report is confidential and it's filed confidential in court. So, in terms of any information that is written, and again, I stress written because sometimes family members will come and they want to talk about it.
Okay.
Yeah, but if it's written, it's going to be in the record at the hospital. So if Deborah comes in and Deborah's placed, but then Deborah acts out and goes back to the hospital, or if I get off conservatorship, they have access to the record because they'll go back through the medical records. But if we're talking about a verbal conversation, depending upon who you're talking to, they may jot some things down, okay? But that may not end up in the record.
Okay. So I'll recommend to that family to write it all down. And
Yes.
Okay. Thank you.
You're welcome.
And if you want to get a guideline or a format in how to do that, the Family Advocate Program does have a form.
Yes.
1424 that is structured and put together. And I can forward that over to you as a guide. What works best is bullet points and the present, but also the historical background, what's going on now, followed by, what has transpired in the last events. But the format is a guide. It's a guide in how to make that information in written form. AB 1424 form from the Family Advocate Program. Write down my email. I can forward that over. Next question. What is the difference between a power of attorney and conservatorship?
A conservatorship is different only in the sense that it goes through the court. It goes through the civil court, where a power of attorney, you're getting it notarized, but it's not going through the court system. So the conservatorship is going to, for example, if you have a power of attorney, but your loved one winds up in a psychiatric hospital and conservatorship is recommended, it is going to supersede the power of attorney. So family members with the power of attorney, it really depends upon what you and whoever's writing it is writing. For example, the person's giving you power of attorney to do what? So the power of attorney is not going to allow you to place a person in a locked facility. It's not going to allow you to medicate them against their will. Those are some of the difference between a power of attorney and, say, an LPS conservatorship. So it really depends upon I call them powers, but it depends upon what you're given at the time that you and the person decide that you're going to have power of attorney over them.
Good. Okay. So a copy of this video. Once we get it done, we'll edit and cut out the unnecessary parts. Everything is very pertinent. We'll make it concise and direct, and it will be available soon enough in our media platforms. But if you can email me, and that way I can get it directly to you. I think that's the route we're going to take with that. Next question. 1 second, please. Let me look at my chat. Let me make it big. For this, what are my options as a 39-year-old of, hold on, let me rephrase that. What are my options as mother of a 39-year-old that refuses care and is unable to provide shelter, food, or clothing for the past 2 years?
Well, a couple of options. One option, is if the person, as a result of a mental disorder, is unable to provide for himself, if he goes in the hospital on a 72-hour hold, then of course the process of evaluating whether he or she is appropriate for an LPS conservatorship. I think the difficult thing for family members is that sometimes their loved one is not quite there, to the extent that they meet the criteria for 5150. And that's sometimes where they get stuck, because what are my options? What can I do? Other than continuing to try to convince your loved one to go in for voluntary outpatient treatment, document that. At some point, the person is likely to end up on a 72-hour hold, and that's where that 1424 documentation comes. So that you have information to forward to the doctor, that the individual is really unable to care for themselves. Because one of the things that is very difficult, and what I say to family members, is that when an individual is 5150 into a psychiatric emergency room, the doctors are seeing today. They're seeing when that person is there. There may be a whole lot of history about what the person is not doing, but they get in the hospital, they eat their meals, they accept their medications, they in treatment teams say that they're willing to be placed in a board and care and augmented board and care. And so those are the things that make it difficult, because the family member's been dealing with the individual for a very, very long time, know that the likelihood is that they're probably not going to make it, in a board and care. They're not going to make it in some place voluntarily, but they have to be given the opportunity to do that, because we can't just lock people up. And that was the whole intent for the Lanham-Petra Short Act, is so that people could not just lock people up. And so I know that's very frustrating for family members, because I hear it all the time that, my daughter's been in ETS 17 times. And, each time they're let out, for various reasons. But the statute is real clear that it is the least restrictive. It has to be the least restrictive. So they have to give them an opportunity. Now, 17 times is 17 times too many. But that's where the whole historical perspective is going to come into play, so that, the psychiatrists and the treatment team have the information that's necessary to demonstrate, that the person really is not able to take care of themselves. And remember, they have access to the records. So they're going to go back and review, what happened, the prior 17 times, and whether this person really is, gravely disabled and, requires a conservatorship. But the conservatorship is not the cure-all, because again, they still have rights. We have to place them in a list restrictive, and sometimes it's difficult for us. We just opened up a 92-bed augmented board and care out in Indio, and we have some conservatives that we thought would do well, and we're having to move them from the lock to the augmented board and care, and because they're not doing well, going AWOL, not participating in treatment, we end up, having to then move them back to an IMD. But having said that, we still have to give them a chance at it. We have to give them a chance, because, what I say to the deputies is, look, if we can get someone off conservatorship after a year, 2 years, 3 years, we've done our job. It's not intended for someone to stay on conservatorship for life. We want them to get the treatment that they need. We want to help them, through our case management services, learn how to make decisions for themselves, learn how to voluntarily accept, treatment, whether it be in a board and care, whether it be in an apartment, whether it be in a shared residence. But the whole goal, is to help them be stabilized and, to be able to take care of themselves. We know that we have some conservatives that's never going to happen. That's never going to be. But it doesn't mean that we don't give them a chance at it. And so, I remind, the deputies, and remind our long-term care staff that, part of what we do is to try to help and to try to give some hope to the conservatee that they, one day might be able, to take care of themselves and be able to manage their own affairs. I don't know if I answered that family member's question, but it's a difficult process. Each case is different. And like I said, I hear from family members all the time the frustration. But the law is the law, and the statute, the way it's written, the courts are not going to allow us to just put a person on an LPS conservatorship because the burden of proof is on us. And so that's why it's important for family members, for case managers, and those clinicians and people who are dealing with the consumers, share information so that the more we have, the more successful we're going to be in terms of trying to get that conservatorship for that 1 year. And I think I might have taken out of the presentation, but at the time that the conservatee is placed on a temporary conservatorship, the public defender is automatically appointed as the attorney to represent the conservatee. And their job is to poke holes, for lack of a better word. If the conservatee says, I don't want to be on conservatorship, their job is to do what they can to get them off. And they're going to do that. They have, we have some pretty good public defenders. They're well-trained. They've been doing this for a long time. And so they do what they can to assist the conservatee to either get off conservatorship or not get on conservatorship at the end of the temporary conservatorship.
Excuse me. Another question. I'm sorry. How do I get started and what are the costs?
So get started with LPS, get started with probate.
Ms. Buray family asked that question. If you can open up your mic and clarify a little bit the question, you're welcome to do so. Get started with LPS or probate. What is this in reference to? Buray family, there you are. Let me ask to open up your mic. If you can clarify the question a little bit.
So I'm not exactly sure which one. I don't even know if it is a possibility. After hearing this, it seems like the person has to be hospitalized or in jail or something like that. My son, he just has like a learning disability, but I don't know how to explain this, but it's just something that was told to me that I should do because he might not be good at his finances and his life. He might have to live with me for the rest of his life. So I'm not even sure where to start, how much it's going to cost us, just to help him out in the long run, to better, for his sake, because he might not make the smartest decisions, with his own life, his own finances, everything.
Well, that's difficult because it's clearly not a LPS. It's clearly not a mental health LPS conservatorship. Now, based upon what you've told me, and even under probate, you're not going to get a conservatorship just because, unless your son is actually gobbling up his money and not caring for himself, the court is not going to appoint you as a conservator just because. So, I don't know why, you're being told that maybe it might be a good idea, because if he's doing this now, where he's not making good decisions and he is not able to take care of his finances, because remember, the conservatorship is even a probate conservatorship is to protect the person from all those things that I talked about, the undue influence, but if that's not happening now, it's going to be difficult for you to go in and to demonstrate to the judge why your son should be placed on a probate conservatorship. So when you talk about how do I get started, you probably, on the probate side, I would recommend that you do some research, because there are some attorneys who specialize in probate conservatorship, and maybe have a conversation with that attorney as to why it is you think that the person needs a conservator. And the cost, it depends. on, attorneys charge different rates for different things. And so I don't have a good feel for how much it's going to cost. On the LPS side, it doesn't cost a family member because we're petitioning the court to be the temporary conservator. And then we're going to go in and recommend that the family member be appointed. Now, having said that, if I can shift over to the LPS, when I talk to family members, I explain to them what their duties and responsibilities are, because you have to shift your thinking from being a parent to being a conservator. And the two things are different. The court is going to sanction everything that you do on an LPS conservatorship. You have to file accountings. You have to file petitions. If the conservatee decides that they don't want to take medication, you have to file that petition. You have to hire 2 doctors, either psychiatrists or psychologists, to write a report to be filed with the court if you want to continue the conservatorship for another year. So once we file the petition and get you appointed, we drop out of the picture. So now you're kind of left on your own. And so I try to explain it to family members, because you have to kind of understand the legal and the court system to be able to do that, unless you have an attorney. We can't mandate that a family member have an attorney, but it sure helps that they do.
Okay, next question is, does the county prefer a relative to a county employee for conservatorship role? Maybe it's referring to the county being the conservator, not an employee specifically.
Well, the CIO unit is going to make a recommendation to the court. If a family member is interested, they are responsible to meet with the family member to go over their duties and responsibilities. And if the proposed conservatee is accepts that the family member wants to be appointed, because remember, they're represented by the public defender's office. If the CIO staff if after having talked to the family member that they believe that the family member really does understand what their duties and responsibilities and is willing to, they're going to recommend to the court that the family member be appointed. Typically, unless the conservatee is opposed, the judge might reverse it and appoint the public guardian's office, even if we recommend a family member. But if that conservatee says to the judge that they do not want the family member appointed, typically they will appoint the public guardian's office as the neutral party. We don't always recommend family members. We try to do our due diligence to make sure that they understand. And typically what I find, I did the investigations for 12 years. That was my first job with the county, actually. Is that once you explain the complications of what they're going to be responsible for, they choose to be the parent and to let somebody else make those decisions about their care and treatment.
I think this isn't somewhere in the same lines. And I think maybe it was touched upon. Is it better for a family member to be the conservator, or is it better for a public conservator? I think
each case is different. In some cases, I have recommended to family members that they probably don't want to do it. There have been cases where I felt that the family member understood exactly what their duties and responsibilities and was willing to do it. So each case is individualized, and it really depends upon, how much the family is willing to put into it to be the conservator. Because the most important thing is that they understand, all of their duties and responsibilities, and that's why I made the statement about being a family member versus being a conservator. Now you're into the Superior Court, in the civil department, where you have to demonstrate, that you have the ability. You have to file accountings. You have to account for every penny of the conservatee's money. You have to file petitions, just like we do. If they need medical care, if they're refusing their medications, you don't get to just sign on the dotted line and place him in a locked facility against his will. You have to demonstrate to the court why that's the most appropriate placement. And one of the, the areas that I often see when a family member is appointed is that they believe that once they get them into a locked facility, that they can leave them there. That is anything but true. The conservator has the responsibility to evaluate often the placement and because the goal is to place the conservatee in the least restrictive setting. So just because they may start out in a locked facility doesn't mean that you can keep them there. They can file with their public defender a placement hearing to say that, that they're stable, that they no longer need to be in a locked facility. So each case is different. And it really, to answer the question, it's really that conversation and that interview between the CIO staff and the family members to get a clear understanding of what the role is and what the responsibilities are.
Great. Next question. If a family member with the mental illness is in jail, what is the process for getting the jail to coordinate with public guardian to start an LPS investigation?
Okay, so it's not the jail. The person has a public defender. Typically what happens is that the public defender will declare a doubt. That means that they're thinking that that the person is mentally ill and cannot help the public defender in court with their case. So it's a process that takes place. And the process is that they declare doubt. The court orders a court-appointed psychiatrist to evaluate the individual. If the psychiatrist, typically there are two psychiatrists, if they come back and say, yes, this person is incompetent and the person is unable to assist the public defender in their case, they will typically either, the judge will either want the person to go to a state hospital, incompetent to stand trial, to be restored to competency. If on the other hand, the court psychiatrist sends a recommendation that the person is never going to retain competency, that's when typically the public defender will request the court to refer the matter to us for an investigation. It doesn't happen overnight because, as I said, it's a process that takes place, and it starts with the public defender declaring a doubt.
Okay, great. Next question is, some time ago, I heard individuals getting lost were moved due to all the privacy by county employees even. Is a person easier to locate now if moved from one place to another?
Okay, I'm not sure of the question that the conservatees lost, because we don't lose conservatees. The conservatee can't be moved without the permission of the deputy public guardian and the long-term care staff who are physically located in the public guardian's office is making the arrangements to move the conservatee. So when I'm not sure of the question about the conservatee getting lost. Only the conservator, whether it be the private conservator or the public guardian's office, can authorize the movement of a conservatee.
Okay, so next question. So if my daughter is overall cooperative on most days, do it be recommended to avoid getting conservatorship for as long, hold on, let me rephrase this.
Okay.
So if my daughter is overall cooperative on most days, there it is, there's a question, I was missing a comma. Would it be recommended to avoid getting conservatorship for as long as possible?
Well, I think the issue before the court would be if the proposed conservatee is cooperative, the majority of the time, there's no need for a conservatorship. So, again, the statute is clear that we should really allow mentally ill individuals options to voluntarily take medications, to voluntarily accept treatment. It is only in the case where they are not willing to do these things, and it's pervasive that the person is not able to make those decisions, then one might consider an LPS conservatorship. But just because a person is mentally ill does not require that a person be on an LPS conservatorship. And that is where I think there's a lot of conflict sometimes between the hospital and family members, because they think that, I just want my loved one on a conservatorship. But again, as I said before, the burden of proof is on the hospital and on the public guardian's office to show cause for why we should ask the judge to appoint a conservator.
So I was the one who asked that question, because from like regional center and like her therapists and stuff, they had recommended it because there are days where she's kind of like, no, I'm not going to do this. And like, but she's developmentally delayed on top of having mental health issues. If that makes sense. I don't know if that helps clarify or not.
Yeah, I understand, except that because part of why I'm struggling with this is for what purpose are they telling you to get to conservatorship? Because you, as conservator, you're still not going to be able to force her to do.
Right. So then
Okay,
so then it doesn't do what I think they're thinking that it thought it would do.
Yeah, and I think that there's a misnomer. Yeah, there's a misnomer, about conservatorship and the powers. The powers that you have. Yeah, I mean, you're gonna have to petition the court. If she refuses to take medication, you can't make her take it. You have to petition the court. The court has to tell you, okay, you have the I'm granting you the power to grant the psychiatrist to medicate her against her will. So, again, we have to think about what it is that we're trying to accomplish when we talk about an LPS conservatorship and or a probate conservatorship.
Okay. And I think they're thinking more like medical and like medical conservatorship more than anything.
That's a probate. Yeah.
Oh, that's
Deborah, this is Greg
okay.
Gainwood.
Yeah.
If I may interject just for a moment, I don't mean to interrupt, but you're talking about a limited conservatorship versus the LPS.
Or she might be talking
The
about
regional
the probate.
centers
Yes.
are going to talk to you about a limited conservatorship of person only. Thank you.
Okay.
Yes.
Okay.
Yes. Yep. And or a probate. It could be a probate as well. But because
Okay. So that helps a lot.
But the reason why I didn't say anything to you about limited, because you said both developmental disabled and mental illness, right? So she has a mental disorder.
Yes.
Yes. Yeah.
Yes.
Yes.
Okay.
Yeah, you can petition the court for a limited. You can petition the court for a probate.
Okay. Good.
You don't need the public guardian's
Okay.
office to do that. Yes.
Here's the additional.
Okay. Okay. Thank you. That helps a lot.
All right,
Yeah,
thank you.
I can see you were thinking. Yes.
All right. Next question. And we have about 15 questions and about 15 minutes to go. So we'll end at 8. So we'll get through it. Just bear with us, okay? Am I hurting my daughter by providing shelter, food, and clothing? The alternatives to her being homeless: she has rats in the home, no electricity or gas. She doesn't even leave the home. Does this make her a danger to herself?
So this is a person that's suffering from a mental illness, and
This
she's living that way in the home.
Miss Miriam?
Do we have an open mental health case? Is she going to any of our outpatient clinics?
Let me open up the mic for Ms. Miriam. iPhone Miriam, let me locate you here. 1 second. There she is. And are you okay with answering that question? I open up your
Yes.
mic.
Yes,
Go ahead.
please. Thank you. I didn't know where to go to find it.
No, I open up
Yes.
the mic for you.
Yes, she has bipolar 1 with psychosis and schizoaffective disorder. And she is living in a delusional state right now. She's been hospitalized 15 times in her life. She started when she was 16. And when she was on medication, she was very active, had her own little business. She was doing well. But when she went off the medication, she decided to go off because she wanted to get a baby, get pregnant. And so she went off her medications 3 years ago, and she's been in this delusional state and paranoia, and she refuses to see any doctors. That's one of her paranoias, is she doesn't want to see anybody, and she doesn't want any help. There's no way to get her to ETS or even to leave the house, really. She doesn't let me inside the house either.
So you have two options. One option is you can make a referral to APS, Department of Public Social Services, or two, you could call our crisis and request our crisis team to try to go out and see her, and evaluate her, and then they'll determine whether they should place her on a 5150 or not. So those are your
Okay.
two options, And typically what the crisis team does is that they will typically call one of our clinical therapists who ride along with the police, and it depends upon where she lives too. But they will ask for assistance from the clinical therapist and the police officer as backup, just to be there with them. Sometimes they'll go alone. It just depends upon what information they get. If they think that it might be a dangerous situation or the person might fight, they may ask for we call them the CBAT teams, to go along with them to be there, for some assistance. They're going to try to do what they can to talk, the person, out of the home into treatment. And then APS does the same thing. They'll go out, they'll make I call a house call, and then they may call the law enforcement, the CBAT team, to ask to come out, right at 5150 if they think that the person, is gravely disabled and what they see in the home is that they're not taking care of themselves. So those are the two options you have. And, quite frankly, we're very excited about our crisis mobile teams because they do very, very good work out in the communities. Did I lose her?
No,
Okay.
I think she's there.
Okay.
Okay, good. Are we okay, Ms. Miriam? Did that answer your question? I hope it did. Your mic is open. Okay, so good. So next question. When a family member is placed on conservatorship, what is there to protect them from possible fraud? What if conservator tries to steal their assets? Can the conservatee appeal in the Supreme Court?
Well, if you're talking about the public guardian's office, that's not going to happen. We have checks and balances in our department as well. County counsel represents us. So there's not going to be any fraud in the public guardian's office. Now, if you're talking about a private conservatory, the court is still the overseer. And so that's why you have to file accountings. That's why they're represented by an attorney, so that hopefully, they're going to catch that. I know that there's a lot of fear, out there. I see, I read, I hear some of the same kinds of stories, but I can assure you in Riverside County, the honorable judge that we have in the probate court is not going to let anything like that happen. And quite frankly, in the public guardian's office, as I said, we have checks and balances. We have our own accounting staff. The deputy is responsible, for ensuring, that their needs are being met. But, like I said, we have our own policies, procedures to ensure that no individual deputy has the ability to be able to take advantage of any conservatee.
Okay, next question. I think this is a group of questions from our group at Blaine Street. There's another question from them. Is the county the sole conservator in the temporary conservatorship?
For LPS, we're the sole temporary conservator. We're not the sole for the permanent conservator. We do have some family members that have been appointed LPS conservators. On the probate side of the house, family members can petition on their own. So we typically get appointed only if there's no family member, or if in the process of the family petitioning for the conservatorship, there's a disagreement between siblings, between husband and wife. Sometimes the judge will appoint us as the neutral party. That's rare, but it does happen sometimes on the probate side.
Is there a gap between temporary and permanent conservator?
30 days. Before the expiration of the 30 days, we have to file the recommendation to the court, either recommending the appointment of a conservator or dismissing the petition. So there's no gap.
Okay. I think this is more of a comment than a question. For the family of a developmentally disabled person, oh, there's a question. How is it limited conservatorship different?
Well, it's based upon the fact that the person is developmentally disabled, and regional center will assist in placement. They're typically placed in a regional center placement, and the powers under the limited are granted by the judge, just as the powers are on the other two conservatorships. But limited is really talking about the individual who's developmentally disabled, and as I said, typically regional center is involved.
Okay. Here's another group of questions from the Blaine Street group. We have 13 people in that conference room. Can two family members be conservators at the same time?
There's nothing to prohibit that, but we strongly don't recommend it. And the reason we don't is because if the two don't agree, it puts the pressure on the conservatee. Having said that, we've had in the past a husband and wife who wanted to be appointed the conservator. And we sit down with them, we talk to them, we try to make sure that they understand and that they're going in the same direction, because the worst thing you could do is to have two conservators, because both are responsible to the court. And no one person is going to have more power over the other person. So they're responsible to the court to ensure that the conservatee is being taken care of. As I said, we strongly try to convince them not to do that, that they should really, the family should elect and decide on one person, so that it is clear to the court who's responsible, who's willing to step to the plate, who wants to take that responsibility. But as I said, having said that, we have in the past, if it's a husband and wife, we typically don't recommend sister to sister, brother to brother. We typically don't do that.
Okay. Next question is, if the county is a conservator, then do parents have any say, power, or say so?
I don't know quite what they mean by say so, because the conservator is responsible for making sure that the conservatee receives the treatment, the mental health treatment that they need, and that they're in a safe environment. Family members call and have conversations with deputies all the time about what they think might be a recommendation, but it doesn't mean that the deputy has the power to do what the family member may or may not want them to do. I think my experience has been that when there's a family member that's involved, that there is conversation and there should be a dialogue between the deputy public guardian and the family member, because we don't want the family members to feel, that they don't have a say. But sometimes recommendations that may come out may in the end not be in the best interest of the conservatee. And that's where the conservator has to draw the line, because they're responsible for the care and treatment of the conservatee.
Good. Next question. Can the conservatee leave the county for a short period of time?
It depends. We have to get permission from the court. We typically talk to the public defender and to the conservatee and to the family member that's requesting to take the conservatee out of the state. And we come up with a plan. And if the person is stable and the family member whom they're going with know that, that they have to take their medication, they understand, we've asked the court sometimes if it's okay. Remember, if they go out of state and they don't come back, because the conservatorship is not applicable when they leave the state of California. So we have no rights, we have no authority. So if they go to another state and something happens, we don't have the ability to be able to force them to come back. So we're going to make sure, one, where the conservatee is going, how long the conservatee is going, and what purpose. And we've had a few that need to go to a funeral, because a loved one died, or to a graduation or something. But those are rare, because as I said, we lose the ability to be able to, because the conservatorship doesn't carry over from California into another state.
Okay. Here's a follow-up question with that, I think. If a conservator travels outside the country, who can make the decisions for the conservatee?
Well, the conservator is responsible. So the conservator has to make decisions. So if they leave the country and leave the conservatee here and something happens, the likelihood is that if the conservatee comes to the attention via a 5150 into a hospital, the likelihood is that the judge is going to appoint the public guardian's office as conservator. So the conservator, cannot leave the conservatee and go out of the country unless they make arrangements for the care and treatment of the conservatee.
Okay. Follow-up question here from the same group. In conservatorship process, is the conservatorship process and laws the same in Riverside County as other counties?
Every county has the same statutes. The Welfare and Institution Code is a state. Those statutes are state statutes. So yes, in all counties, the process is the same.
I think it's from the same person. For example, if the conservatee is conservatized in LA County,
okay.
and moves to Riverside County, are the transfer easily made, or what needs to happen?
The conservator who moves the conservatee to Riverside County must petition the court and have the conservatorship moved from one county to another county. So the onus is on the conservator to petition Riverside County Superior Court to request that case be transferred from Los Angeles to Riverside.
Okay, good. What would be the best option for a senior who has dementia? She's bedbound and she's nonverbal. Her cousin wanted to get power of attorney, but was informed that she could not get it no more due to her condition.
That's true. So you're looking at a probate conservatorship. And that person can petition the court for a probate conservatorship.
Okay. Can we please get more information on the mobile crisis team? You're welcome to contact Ms. Jackie Sanchez or myself. My information is there on the chat. I think I'm going to write it down again. So it's right now at the bottom, and I can get you that information followed throughout the week. And I'll put my information, my contact, and my email on that thread. And we'll talk about details of where you're located, in what cities, and which is the best way to access them. Okay. That was easy for me. Okay, next question. I might have misunderstood. This is, 1 second. I might have misunderstood the LPS conservatorship process, but as I understood, the ETS psychiatrist can initiate LPS conservatorship. So what triggers them to initiate the process? If you have someone that is in and out of ETS, wouldn't that be enough for the psychiatrist to start the referral for the court?
No, there is a little bit of misunderstanding. They're going to go into ETS on a 72-hour hold. Remember, they're not going to stay in ETS for very long. If the psychiatrist in ETS determine that they need further care and treatment, they're going to keep them and move them over to the inpatient, which is ITF, same location, but over into the inpatient. It is the inpatient doctor and the treatment team that's going to take the next 10 days out of the 14 days to continue to get information to try to make a decision about whether the person should be placed on a conservatorship. Keep in mind that sometimes when our loved ones go into a psych emergency room and or an inpatient and receive medication, they stabilize pretty quickly. If there's a plan that seems a viable plan for the individual, they're not going to recommend an LPS conservatorship. So the fact that a person goes in and out of the hospital in and of itself is not a reason to place a person on a conservatorship. If, however, they're going in and out and they're living in fifth, and they're living in a situation that's unsanitary, they're not eating, they're not clothing, then that gives the doctor a little bit more to think about whether, in fact, as a result of this mental disorder, this person is unable to care for themselves. So they're looking at when the individual is discharged, where did the person go? Did the person go back home? Who does the person live with? Are the family providing the food, clothing, and shelter? Are they accepting the food, clothing, shelter? Because if they don't have information to the contrary, then if the patient says, I can return to my home, it is on the onus of the social worker to verify that information. But those decisions are going to be made when the person is moved over to the inpatient side of the hospital. But just hospitalizations alone is not reason enough to put somebody on conservatorship.
Okay, let me look at the questions here. A lot of thank yous in regards to your responses, Ms. Johnson. A lot of Jackie Sanchez information for her, for the attendees. NAMI Temecula is going to have a presentation on mobile crisis team. You
Good, fantastic.
NAMItemecula.org on mental health forum for information. A follow-up question for our NAMI affiliate, NAMI Temecula. Is this presentation going to be available through Zoom?
Yes, it's through Zoom, May 19th. It's every first month, the third Wednesday of every month. You can go to namitv.org. I'm putting up the flyer today, so you'll be able to get the Zoom info. It's
if you can forward me that flyer, we always collaborate with you guys, and I'll forward it to our families. I'll be more than welcome to do that and advertise for you guys.
Excellent, thank you.
You're welcome.
In addition to that, Pedro, I'm on my iPad. So if you could put in my information, my name, phone number, please, any family member that's got a follow-up question, or if they need some advice, feel free to call me.
Okay, Deborah Johnson, and a number you would like them to call you, Ms. Johnson?
It's 951-955-1503.
Okay. There you are. And it's on the chat. It doesn't get better than that. And then it's been very helpful. Second Wednesday of the month, more announcements. Any other questions that you may have? Thank you, Ms. Johnson. Great session. Looking forward to the next criminal justice meeting. It's available through Zoom. I'm assuming that's an invite for all the families that can join. I'm
Yes.
making an assumption,
Yes.
Commissioner Dingwood, but families are welcome to attend this commission meetings. So your input is very valuable. Alma also put her phone number there. Francisco is another one of our family advocates, and he covers the Western region. So for the families in attendance here, you have an array of information. I don't see any last minute questions here. Anybody else? Here we go.
Pedro, okay, yeah, the form, what's the form number?
Yes, the form is called, we have it in-house, and it's AB 1424, a form. You can email me and I'll forward that to you tomorrow. It's very simple. Collateral information, AB 1424.
Thank you.
And you can email me tomorrow and I'll forward that over. Ms. T. Carell, if you can open up your mic, please.
With the 1424, is that information then stored in some type of a database? Because I had the same conservatee who was going from hospital to hospital and also from county to county, and all the information wasn't getting relayed. So what happens with that 1424 information? Is it just for the one hospital?
Okay, yeah. Every time they go in, the family member is going to have to get information. That there's no database that we share information with other hospitals. That just doesn't happen. It's very difficult for us to share with each other without the consent, the individual. So
Okay.
to answer your question, for Riverside, is going to go into they're going to store it into the electronic medical record, because we've moved away from the paper stuff. So, so it will be filed in their electronic medical record. But if they go into some different hospital, the family member is going to have to get that information to that hospital.
Okay.
Right. So what we ask families to do is to make multiple copies and leave a blank one to keep updating it as new hospitalizations happen, to provide brand new information, change of medication, change in psychiatrist, but to always keep one or two extras updated, because they have a limited amount of time before they can get that to the treatment team in order for that investigation to get started. So we don't have time to be on a downtime on those good moments. Fill it out on a timely manner and have it prepared just in case.
Okay.
If you never need it, great. But if you ever do, it's better to pre-prepared.
Okay, thank you.
All right. 1 second. Just being homeless doesn't mean a person needs. Okay, we have another question here. Just being homeless doesn't mean a person needs conservatorship, right?
Correct. But we have a homeless outreach team that, we can employ to go out to take, talk to the person to try to get the person to, agree to shelter. We have emergency shelter, and, they will also do an assessment to determine whether the person is, as a result of their mental disorder, if they're really gravely disabled, in addition to being homeless. So they might recommend a 5150 and get the person into hospital, especially if it's a homeless person who needs some medical care.
Good. Here is another question. When is it not good to have a family member as the conservator?
When is it not good? That's a difficult question, because it really comes down to the conversation that we're going to have with the family member. I can tell you that it's not good if the conservatee is refusing and is fighting the family. When I say fighting the family being a conservator, that's never good. And sometimes proposed conservatees will rather have the public guardian than to have a family member. But, again, just because they don't want it doesn't necessarily mean that it won't happen. And that's why I think, there has to be a candid conversation between the CIO investigator and that family member to determine, whether that family member should or should not. And there have been times when I frankly sat down with the family member and said, that it's going to be more trouble than it's going to be worth. And that maybe what you want to do is to be the loving parent, and not have to make those decisions that the conservatee's not going to like, that you're going to have to make, to let, somebody else do that and you just be the parent. And some family members agree, and some will say, I still think I want to be. And, quite frankly, I've communicated with family members that I thought were very capable, that they understood that their role wasn't going to be a family member, and that they were going to have to make difficult decisions. And the conservatee ain't going to like it, but it's in the best interest of the conservatee. So it really does depend, on the individual case and having that candid conversation with that CIO investigator.
Commissioner Dame Goodwood, Marcus Cannon is a real help for the homeless. And a follow-up questions, can we get more info on the homeless? So we do have the program Home Connect that works with the homeless population. Feel free to give me a call tomorrow, or my information is there, or shoot me an email and we can connect you with also to determine how we can best assist. This comes from probation. So we'll connect you to the service. I would love to have a copy of the presentation if it's possible. Again, absolutely. Once we get all the slides tomorrow or in the next couple of days, feel free to shoot me an email, and I will forward that over to you. The form you just mentioned, this is okay. Yes, I will. You have my email. This is okay. I will forward you that email, Ms. Olga, I think. Homeless Outreach Team from Kristen Duffy, 951-715-5050. Hope is the name for the Homeless Outreach Team. Let me see questions. There can be Home Connect. We have, there it is, the number for Home Connect. I hope everybody can follow through. Everybody's just jumping in with resources. I love it. This is what our support groups are beneficial. I'm going to share with you tonight, because what one of our families has tapped into, it may be news to another family member.
Absolutely. Yes.
Hand up for Ms. T. Carell. If you can open up your mic. Or is it an old raise hand?
Old one, sorry about that.
Okay, very good. The SWAG team, I love this, sharing the resources. SWAG team has been a big help. They fill in the gaps for other programs. The link is there. Trying to keep up with this chat. When can I listen to the recording? We will edit in the next couple of days and have those available through our social media and outlets. And if you can email me, I can probably forward that to you. And I think that's the end of the chat. Any last burning questions that we may have? Are you guys, I think Ms. Johnson was very thorough. A lot of questions were answered. Any other? And also, if you can let me know in the chat, just a quick drop, what's the best source to get this information about our presentations to you? What do you use the most? Do you use Facebook? Do you use Instagram? Does email work? What works best to connect with you? Just a quick email. Okay, we have a lot of, I'll read this through over. Any last minute questions for Ms. Johnson? And the chat is dropping. Thumbs up from Miss Jared Farnsworth. Everyone's here. Everybody at the team at the Blaze support group says Miss Jackie is my best source of information. I love that. Okay.
Okay.
So I think we were very thorough. iPhone Miriam, you have your hand up. If you can open up your mic, let me do that again for you.
Yes, I don't want to take too much of your time. My call dropped and I just, and I missed, I'm going to listen to the recording later, but I did want to know if the bad situation in which my daughter's living without electricity and gas and with rats in her house, does that make it enough to be a danger to herself?
Well, I'm not going to be presumptuous and say yes. What I would recommend is that either the crisis team or APS go out and evaluate the situation.
Okay, thank you.
Right. And then if you can give me a call tomorrow, we'll talk about how to connect you to those services with the mobile crisis team or the CBAT, or like Ms. Johnson said, with APS, okay?
Okay, thank you.
You're welcome. My information is there. Again, more sharing of resources. I love it. So looks like a lot of people are expressing their gratitude, and I'm not going to be left behind. Thank you so much. I
You're
think
quite welcome.
our families feel very comforted that you are an ally, and you always have been an ally to them, and that they have someone on their side. Sometimes it feels like with this complex system, it feels like no one is on our side.
Absolutely.
But just that you being here for us and for them, really, it's heartwarming. And it makes us feel so much comfort knowing that you're one phone call away, literally.
Absolutely. And I'll end, with every morning that I get up, I am excited to come to work because I know that I'm going to help at least one consumer and one family member. That is the reason I come to work every day. And that's why I've come for 43 years, almost 44 years. So anything I can do to help, don't hesitate to give me a call.
Great. All right, very good. I'm gonna open up the mics and we can give it a round of applause.
Thank you. Thank you all so much and have a nice evening.
You too, Ms. Johnson.
Okay, bye-bye.
Thank you.
You're welcome.
Thank you. Thank you so much.
You're
Thank
welcome.
you, Pedro.
You're welcome. You're welcome.
Thank you very
everybody.
much.
Thank you both.